legal issues on the matter of cross-border insolvency in Indonesia based on Law Number 37 of 2004 on the insolvency and the postponement of debt payment obligation. But first, let us introduce ourselves. My name is Venty Utami. I work at the Indonesian Ministry of Law and Human Rights. I work together with Mr. Ilham Djaya, a Dean of Faculty of Law of the Universitas Kader Bangsa, Palembang, to compile this paper. This paper aims to spot how Indonesian insolvency law regulates the insolvency case with foreign elements. The issue of cross-border insolvency is growing rapidly in line of the global economic movement. The foreign elements of the insolvency process raises question on the state's jurisdiction, the court's authority to adjudicate the case of cross-border insolvency, the recognition of Indonesia's court decision on insolvency in another state, as well as the issue of curator's authority to cooperate with another state officials. As we know, the core point of international law is the sovereignty principle. Therefore, each state has absolute power and authorization over its territory, and therefore can only be prejudiced by the reciprocity principle. In the general understanding, a state can only allow the execution of an insolvency decision by another state if there is an agreement between the states, either through bilateral or multilateral agreements. Indonesia regulates the issue pertaining to insolvency through its Law Number 37 of 2004 on the insolvency and postponement of debt payment obligation. Through its provisions, Indonesian insolvency law regulates the cross-border insolvency in a limited manner. Therefore, the situation may bring some confusions and new legal issues, such as the inconsistency on the application of the legal principles in Indonesian insolvency law, which leads to the unrecognition of Indonesian insolvency decision outside its territory. Second, the challenge on executing the debtors' estates located outside the territory of Indonesia. And third, the issue on the legal uncertainty that may be faced by the creditor while accepting the payment of that claim. At the end of this paper, we are able to identify the measures that should be taken by Indonesia to resolve such rising issues. For instance, by increasing the Indonesia's participation in international agreements, either bilaterally, multilaterally, by adopting the UNCITRAL model law on cross-border insolvency with guide to enactment in the matter of cross-border insolvency, or by strengthening the diplomatic relations. Another possible manner is by reforming the existing Indonesian insolvency law, since in line with the development of society needs, the provisions in the insolvency law are deemed necessary to be reformed, especially in the matter of foreign elements in the insolvency proceeding. Last but not least, we believe that by improving Indonesian regulation pertaining to cross-border insolvency, it will bring a great impact on the increasing of Indonesia's economy, since it will attract foreign investors to invest in Indonesia. Indonesia would be considered as having a good legal framework in the economic sector and relatively safe to be invested. Thank you for having us and have a nice day.